Good afternoon, Chris Gantt-Sorenson and partner Perry McLennan here with me, and we are looking forward to talking to you about what to look for in both the federal and the state legislatures as far as employment-related legislation that might be coming down. We're excited to see everybody. We're happy everybody's doing well. So we'll just jump right into it. We've got lots of things to cover today. So as always, most of you are probably on our blog, and that's how you found out about this. But if you're not, jump on our blog. If you've got questions or comments that you want to make throughout, go ahead and do so in the chat or the Q&A. And as you know, Perry and I will address them as they come up, maybe live or to group responses. And as always, we are offering SHRM and HRCLE credits, and so look for that information from our marketing department, Brittany Hill, who's here with us today, and it's always helping us, and she'll be sure to get you what you need. All right, so we're going to start with the federal vaccination legislation, and so we've got obviously some good news on the federal level to report about that. We're going to talk about the marijuana legislation in South Carolina and the pay equity legislation in both federal and state, and then a few other federal updates for Build Back Better, what you might anticipate, assuming that does pass. So we'll jump right into the vaccination federal updates. Next slide. As you know, the OSHA's ETS that applied to employers, private employers with 100 or more employees, was blocked by the Supreme Court. That was on January 7. And so good news, employers don't have to worry about that. Many employers were relieved. As far as the CMS vaccine requirement rule, that was also heard by the Supreme Court on January 7, and that court did not block it, and so that is enacted. And right now, anyone who meets the definition of a Medicare or Medicaid health provider has to comply. Federal contractor, we'll talk about that, and then the OSHA healthcare ETS. So let's pop right on to the next slide. As I indicated, OSHA's ETS was withdrawn. That's the history of it there. And, as a reminder, that's the one that had a mandatory vaccination policy, or you could have an either or, a vaccination policy or a masking and weekly testing requirement. Next slide. So OSHA responds after the January 7 ruling. Well, the January 7 hearing and the ruling was I think sometime the next week on Thursday, was it, Perry? The 13th? Yeah. On January 25, OSHA issues a withdrawal of its ETS effective January 26, so that was yesterday, and said the agency is going to prioritize its resources to focus on finalizing a permanent COVID-19 health standard. So, OSHA is redoubling its efforts. I don't know what that looks like. Presumably, OSHA's drafters will take into consideration what the Supreme Court did with the ETS and won't draft something that the court will then have to block again. Labor Secretary Marty Walsh did a news release on January 13, the day that the Supreme Court ruling came out, and said specifically that OSHA is going to do everything in its existing authority to hold businesses accountable for protecting workers, including the COVID-19 National Emphasis Program and General Duty Clause. Translation, OSHA 3300 is still absolutely what employers need to be following, and just because the ETS didn't go into effect does not mean that the employers don't need to continue following that guidance under the General Duty Clause, as well as any updated CDC and OSHA guidance. So you'll have to stay current with that, but you've been doing that presumably since 2020. So this is good news for private employers. Next slide. The CMS vaccine mandate. What was interesting about that is 25 states were adhering to it and 25 weren't. 25 had joined a group that had it stayed. It's now in effect for all healthcare providers who participate in Medicare and Medicaid programs. And it's a mandatory vaccination, no either or opportunity here. I believe healthcare providers that are subject to this were very familiar with it and ready to go. Its implementation dates are today, first dose of vaccine today, and all staff must be fully vaccinated by February 28. All right, next slide. The federal contractor and subcontractor vaccine mandate, which was also a mandatory vaccination requirement, that has stayed nationwide. And so not really sure what's going to happen with that. That may have just died on the vine. I'm not sure. Perry, do you have any idea?
No, I don't. I'd be sort of surprised if it moves anytime soon. I think that the administration probably has a lot less willpower at this point to keep pressing that. I mean, being cynically, even just in political terms.
Right.
So wouldn't be surprised, but we'll keep you posted.
Yeah, that makes sense. I agree with everything you said. All right. And then the last slide is about the OSHA, the healthcare ETS, which that was withdrawn. OSHA issued that back in June, you may recollect. It was stringent, had pretty stringent pay provisions. And once it did not offer a proposed rule, which you have to do, your ETS can only stay in effect for 6 months. Once it did not offer that within the 6-month time period, it had to withdraw it. We don't think that's going to be coming back. So that's it for the federal mandatory vaccination guidelines. And there it is. That's the summary. And so Perry's going to talk to you a little bit about the state laws, because the truth of the matter is now a lot of this reverts back to state legislation. And so it is going to be important to keep your eye on what South Carolina passes here in this term.
All right. Thanks, Chris. Yeah, I think the only other comment maybe I'd make on the sort of where we stand with OSHA is, from my perspective, it sounds like the Department of Labor is coming out and sort of saying that they're going to try to implement a permanent rule, which means, that they'd have to go through the normal regulatory process of implementing a new regulation. And I mean, from my perspective, based on the Supreme Court's opinion, I don't even really know how they could do that. I don't know how they could write one that would pass constitutional scrutiny based on the opinion we got from the Supreme Court. So I'd be a little bit surprised personally if that does happen. But as Chris pointed out, OSHA does have this general duty clause, which requires employers to provide a safe workplace for all their employees, and OSHA retains the right to cite companies for violations of that. And when it comes to COVID, we don't exactly know, what those would be. But as Chris mentioned, certainly failing to follow, quarantine measures and things like that could certainly still get you in trouble with OSHA, even though this vaccine mandate is no longer in place. I did see that one of the big manufacturing industry groups has sort of come out and said that they still think some kind of vaccine or testing policy is a good idea. So if you're still considering it, you certainly still have the latitude to implement something like that. You can be a little bit more, or we as lawyers can be a little bit more flexible in how we draft those. And it still could be a good idea for your organization, even though it's not mandated. So keep that in mind. So moving over to South Carolina, as most of you probably know, the General Assembly is back in session now. They're in the second part of our General Assembly has a 2-year session, so they're in the second part now. And we're keeping our eye on a bunch of different vaccine bills that have been introduced. There's been a bunch of bills introduced. It's one of those things. I think a lot of politicians try to score political points by introducing some of these, because there's just so many different ones being floated around out there. A lot of this, I think, was done in response to the federal OSHA mandate. Is sort of hey, South Carolina is not going to follow that. And so apparently our colleague, Katie Busby, was talking to some folks, I think, over in the State House just about these COVID bills. And it sort of sounds like maybe the announcement from federal OSHA dampened some of the enthusiasm to really push these through the legislature this year. So we'll see what happens with them. They are, I mean, these bills would have a big impact on all of you if they were passed. So it's definitely a good idea to for us to keep our eyes on them. But it's kind of hard to say at this point in time, you know, how large of a priority these are and how likely they are to pass. But we'll go through a couple of them here just to sort of let you know what's being considered in case, you know, you or any industry group want to voice your opinion on the legislation or just to be able to keep your eye on them. The first bill is House 3126, the COVID vaccine ban. It did pass the House on December 10th at a 67-31 vote. Apparently, there's been no scheduling of any full vote in the Senate. I think it's still in Senate committee, and it didn't seem like there's they're thinking it's going to get out of Senate committee anytime shortly. But you can see the provisions of the bill. Basically, it would bar the state political subdivisions and school districts from mandating the vaccine as a condition of employment or attendance. State political subdivisions can't terminate a first responder who chooses not to be vaccinated. And interestingly, for private employers, any individual who is let go from their company because they've chosen not to be vaccinated, it would make that person eligible for unemployment benefits. So that's the piece of it that would impact those private employers. And that's certainly an interesting one. We were on a South Carolina Chamber call about this, and I sort of heard from employers that were sort of on both sides about this. Some employers sort of said, well, you know, if you're giving somebody the choice of vaccine or job, probably fair that, you know, if they're going to have to look for another job, they get unemployment benefits. And then I heard from some employers, well, and it's just like any other failure to follow company policy, you know, isn't this really a for cause termination? So I kind of heard on both sides of that. But this is the bill that probably, because it's already been voted on in the House, it might have the easiest path to move forward. There's a few other things in here if we go to the next slide. And one, you'll see starred there, states that a religious exemption or medical exemption must be honored in regards to any COVID-19 vaccine requirement. And interestingly, included within the definition of a medical exemption is the presence of antibodies, a prior positive COVID test, or pregnancy. And, you know, a prior positive COVID test, I mean, that covers about everybody at this point, I would imagine. You know, people are getting it multiple times. So not sure that's necessarily should be a valid reason for a medical exemption. But that's what they've written into the bill here. As you can see from the bill's language and from all these that we're going to go through, there's a certain, you know, certain of our politicians are sort of very, very adamant that people should be given free choice as to whether or not to get the vaccine, and they shouldn't be required to get the vaccine to attend anything like school, and they shouldn't be required to get it as part of their job. And so, you know, they're putting provisions in here like this, like the medical exemption and religious exemption one that sort of are creating all these exceptions to the rules. So it's a little bit interesting. I imagine that if this bill moves forward, that provision would probably be cleaned up a little bit, because I think that's problematic. Now we've seen the Omicron variant come through, and so many people who have been vaccinated, you know, testing positive, people getting it multiple times. I have heard of people, you know, testing positive twice in, the span of a couple months on different occasions. So that's something that might have to be looked at. A couple of other bills that we've got coming through. One is Senate 902, COVID vaccination, workers' compensation. And it would make compensable under workers' comp all adverse health conditions or death as a result of receiving a COVID-19 vaccination mandated by an employer or the government. And again, this was, this I think was sort of in response to the federal OSHA requirement, but it would also apply to, like I was talking about earlier, if your organization decides, okay, for whatever reason, we're still going to have a mandatory vaccination program, and an employee gets the vaccination, there's an adverse side effect from it, then that would be compensable under workers' comp. And this is one of those that kind of goes both ways for employers. On the one hand, you may say, well, that shouldn't be covered under comp, and maybe it's unlikely to have adverse side effects. But on the other hand, workers' comp, as most of you know, is an exclusive remedy. So if an employee gets workers' comp benefits for something, then they can't sue the employer over that. And so in some ways, this is sort of a pro-employer bill here. And so we'll see what happens with that. House 4560, companion Senate Bill 889, South Carolina Vaccination Rights Act of 2022, makes it an unlawful discriminatory practice for an employer to not deny employment or discriminate against an employee based on the person's refusal to provide vaccination status or based on whether the person has immunity passport. So again, sort of similar idea to pass a law to provide protections against unvaccinated persons and to not require people to disclose that. Even if you don't have a mandatory policy, that there may be fears that disclosing the vaccination status, some employers may discriminate against those workers. And so that's what that's what that's trying to accomplish there, sort of an anti-discrimination measure. And a couple more provisions of the same bill allows employers to recommend or actually to incentivize vaccinations, although adds vaccination status as a protected class under South Carolina Human Affairs law. So, exactly what I was talking about earlier. There's this fear that even if you don't have mandatory testing policy, requiring employees to disclose whether they're vaccinated, maybe in a job interview, is going to lead employers to say, okay, we're not going to hire people that aren't vaccinated because it's a risk to our workforce, or they're going to be out on leave, or this or that. There's a concern that there might be some discrimination there, and so that's what this bill is trying to protect. Senate 177, COVID-19 vaccinations is the title of that bill. Same kind of thing, bars mandatory vaccinations and has anti-discrimination measures in there. This one does provide exceptions for employees and contractors working for an entity who cares for vulnerable populations. So you have nursing homes and organizations like that who have a need because of the population that they serve, are exempt from this bill. And again, this one allows employers to offer incentives as well. Next slide, if you don't mind. So one question that we've sort of been getting a lot of discussions with clients is sort of how do we reconcile what's going on at the state level and the federal level, and what happens if a state passes a law that's in conflict with a federal law or federal regulation. And there's a constitutional doctrine of preemption. And now that the OSHA vaccine mandate has been blocked, some of this is moot, but it still could come up again, and it's good stuff to know. But generally, when there's a direct conflict between state law and federal law, the federal law preempts the state law under the supremacy clause of the U.S. Constitution, which that says the Constitution and the laws of the United States are the supreme law of the land, which judges have interpreted to mean that if there's a direct conflict, then the federal law would supersede the state law. And you see that sort of all the time with respect to bills that are being argued in the General Assembly in South Carolina. Well, can we do this, or is it in violation of federal law? And again, as of right now, we don't really have that come into play. Although for those employers who are subject to the CMS vaccination requirement, depending on if any of these bills in South Carolina pass, employers in South Carolina could be put into a situation where maybe they've got to comply with the CMS rule, but they're violating one of these new South Carolina laws. And again, that's getting a little bit ahead of ourselves, but it is possible. I see there's some activity going on in the chat and some questions, and so feel free to use that. Keep using that if you have questions about any of the OSHA stuff. That's, I think, all for the most part we're going to talk about. The vaccine stuff, we're going to move on to other issues. But again, feel free to. Chris, was there anything you wanted to we needed to address out loud before we moved on?
No, I would say that Wayne Music has an interesting question for you in regards to the next topic you're about to cover. He wanted to know how the preemption information that you just covered in regards to vaccines would apply to medical marijuana.
Gotcha. Yeah, it is a good question. We're about to talk about medical marijuana, and this has been in the news the last couple of days. Some of you have probably seen it. For the first time in South Carolina, the medical marijuana bill that has been around for about 7 years, that Senator Tom Davis and Beaufort introduced and has been a champion of, that I remember predicting about 5 years ago would pass, is just now coming to a vote, which it is a significant step. I mean, up to this point, the opposition to it's been strong enough to keep it even getting to a vote, and now there does seem to be a bigger groundswell of movement. Congresswoman Nancy Mace was just at the State House rallying for it. I think that was yesterday or the day before. And so it's got sort of powerful groups on both sides. I think Governor McMaster's still against it, SLED's against it, but there are a lot of powerful Republicans and Democrats who are in favor of it. And I would say again today that I do think it's a matter of time before this passes. This is called the South Carolina Compassionate Care Act, Senate Bill 150. And this, it's important to note that this is a medical marijuana bill. So it only would allow certain individuals with a qualifying serious illness, which we'll talk about what those are, the ability to use medical marijuana if they've got a written note from a doctor prescribing it, essentially. And then with that note, they could get a registration card from DHEC, which, essentially it decriminalizes this at the state level if you've got the registration card. What that means is you would not be arrested by SLED or local police for as long as you were in compliance with this law, even if you were in possession. Now, to Wayne's point, as most of you know, this is still classified, marijuana is still classified as a controlled substance under federal law, which does preempt state law. And so theoretically, you could be arrested on federal charges for possession of marijuana. And I'm starting to veer a little bit into territory that I mean, I'm not a criminal lawyer, so I'm veering a little bit outside of my comfort zone. But basically, with regards to the federal controlled substance, for a long time now, really since at least probably President Obama's election in 2008, and this was even true under Trump, the federal government has taken a very, very hands-off approach to marijuana. There is almost zero enforcement of it. I mean, there's some enforcement over drug trafficking and things like that, but federal enforcement of, possession of marijuana and things like that is just not enforced anymore. So that's kind of where the preemption. I mean, lots of states have obviously passed both medical and recreational marijuana. Users in those states seem to have no issue with the fact that it's a controlled substance under federal law. Really, the fact that it's a controlled substance under federal law presents problems for growers and businesses, because they have trouble getting bank accounts open and things like that because of its classification. But for everyday user, because of the lack of enforcement, that federal controlled substance designation generally does not affect their day-to-day. So what would be the qualifying conditions that would allow someone to get or that doctors would have to follow in order to write a note for somebody to get a medical marijuana card? And I've got them listed up there. I won't read them all out, but it is, I mean, you will see that the drafters of this bill have, taken pains to make sure that these are very serious illnesses that we're talking about, the cancers, MS, neurological diseases, things like that. I mean, there are a couple of things in there, like PTSD and stuff like that, sort of get into the psychiatry type of element. But for the most part, these are sort of, I'm not suggesting it's not serious, but a lot of these are sort of very illness, life-threatening illness type of thing. There is sort of a catch-all, says, or chronic condition for which an opioid could be prescribed. And so, there is a little leeway in this bill potentially for physicians to write prescriptions. And so, we would just have to see, how common that would be and how strict doctors would be about it. I think I saw Chris's question pop up about that this only allows marijuana in liquid or edible form and not smoking it. And I thought that was in here, but I'm not seeing it. But that is true. You still would not, even under this bill, be able to be in possession of marijuana leaf to be able to smoke, but the prescription would only apply to that in liquid or edible form as well. There are obviously, how does this impact you as HR or business owners? This obviously is going to impact the labor market. We've seen in other states that have legalized either medicinally or recreationally, that you can't sort of separate it from, your workforce. I mean, you're inevitably going to have somebody that's got a card and is using. And so how do you deal with that? Well, the drafters of the bill have obviously thought that through, and they've put a number of business protections into the bill, built them into the bill, and you'll see those here. It says, you'll see right there in business protection, the rights in this bill do not apply if they conflict with federal law. I don't know what to make of that statement. I mean, I think that if passed, the rights under this bill would have to be followed, and we might talk a little bit about that when we talk about the potential ADA accommodations and things like that. but the general principle is that employers can still have sort of drug-free workplace policies despite allowing medical marijuana in South Carolina, that employers don't have to accommodate use on site, possession on site, or being under the influence while at work, even if you work remotely. And it doesn't limit an employer's ability to discipline employees for violations of their drug-free workplace policies. And so, I mean, what that basically means is that if you've got an employee who tells you, look, I've got this, I've got this condition, glaucoma or whatever it is, I'm prescribed medical marijuana. I use it daily. It's a small dose. It doesn't really impact me, but I'm just letting you know that, it is going to show up in a drug test. I'm going to fail drug test if I take it because I'm, prescribed this daily. The way this bill is written, you could still enforce your drug-free workplace policy and say that's a violation of our zero tolerance policy. And you would not have to employ that person under this bill. And so, I mean, they've sort of, they've made it, as friendly to businesses as they can. Now, in other states, there has been a lot of litigation over this, over whether, people trying to say, well, it's not really discriminated against because of my marijuana use, but it was because of my glaucoma, and that's a disability under the ADA and stuff like that. And, so far across the country, the decisions have been pretty pro-employer on that. But again, that's sort of advising clients and sort of how to handle those situations sort of beyond today's scope. If and when a bill like this passes, we would certainly have more information about how employers should respond to it. So the one other thing, the bill specifically states that it does not create a private cause of action against a private employer for wrongful discharge, discrimination, or any other adverse employment action. So there you go. Not to say that plaintiffs' lawyers out there won't get creative and again try to bring these claims under some sort of ADA claim or something like that, but they certainly would not be able to state a case for something like wrongful termination in violation of public policy, because it's obviously stated in here that the public policy behind the bill is to not create a private right of action for someone for wrongful termination. So we'll see where this goes. I mean, I think that prognosticators are, probably not thinking that this is going to pass this term, but we're definitely headed in that direction. I mean, every year they've gotten a little bit more support behind it. Now it's going for a vote. Public opinion, if you look at the polling, is very much in favor of something like this, even in South Carolina, across political lines. And so would not be shocked for something like this to be coming our way. And if it does, again, I do think it's going to have a big impact on employers. So we'll be doing, more webinars and blogs and things like that on how to handle it. All right. The last thing that I'm going to touch on as far as South Carolina employment law updates or legislative updates that you might want to keep your eye on is pay equity legislation. I've done a couple of presentations last year just on this topic, and we won't get into the nitty gritty of what pay equity is and what the current law states and that type of thing, but it is sort of a hot button issue. It's been on the General Assembly, on some legislators in the General Assembly's to-do list for a number of years. There's been a couple of bills out there it's one of, if not the top legislative priority now for the South Carolina Women's Rights and Empowerment Network. And so would not shock me if there's a world in which South Carolina passes some type of pay equity bill, like South Carolina did with pregnancy accommodations and lactation support, those types of things. We've seen this type of legislation over the last couple of years. And really the idea behind these laws, and I've got some background up here on pay equity, but really the idea is that there's still a persistent pay gap between male and female employees. It's particularly stark when you start to look at minority females as well. And so it's sort of this persistent problem. And, I won't get into the sort of all the reasons why people think it is, but legislators have been trying to do something about it. Basically, they've said that our current laws are not adequate enough. They basically allow employers too many ways to justify pay differentials that are really, thinly veiled discrimination, really. And so that's what this is all about. If we go to the next slide, you'll see what some of the numbers are. That the chart and these statistics do come from the Women's Rights and Empowerment Network, as is a presentation with Brandy Paris Ellison last year on this topic, and those are some of the numbers there, and you can see why it's a top legislative priority for them. There are current legal protections in place. The Equal Pay Act at the federal level, as well as Title VII of the Civil Rights Act, both prohibit discrimination against anyone based on any protected class. The Equal Pay Act, just men and women, but Title VII, including all of the other, race and national origin and those types of things. But it does allow employers to justify pay differentials based on any reason other than sex. Any reason that an employer could ever think of, as long as it doesn't have to do with sex, then that's a justifiable pay differential. And so what these laws that we're about to talk about next, there's South Carolina legislation, Act to Establish Pay Equity, House Bill 3183, and a companion bill in the Senate 514. These laws really try to change that last part. And if you'll go to the next slide, you'll see here written out sort of what I'm talking about. And this bill would ensure that jobs that require the same skill, effort, and responsibility be paid the same. And if there is a difference in pay, so if you've got two people that have same skill, effort, responsibility, same job title, same department, who have a difference in pay, there's got to be a business factor for that. Not any reason other than sex, but a business factor. You got to be able to point to, hey, this person's been here 10 years, this person's been here 2. That's that's the difference in the pay. Or this person negotiated with us, this pay, in a recruiting effort to get them. That's what we had to pay them. Those types of business reasons, even under this legislation, would be justifiable. It would also add protections for job applicants. Many people think that really where this is starting is in the sort of job search process, where employers are asking applicants to disclose their wage history and what they would, what they've made at previous jobs. And so that's sort of perpetuating the issue. And it would increase transparency and compensation discussion, requiring employers to give position ranges to job applicants and to current employees, update that on a regular basis as well. As I mentioned, they've, in addition to the business factor, they've built in certain exceptions as well, which are on the next slide, which are seniority system, merit system, production based system like commission or other business factors like education or training and things like that. And so this bill would, if passed, create a right of action under South Carolina law, which would, probably increase pay discrimination litigation in South Carolina. It would allow individuals to bring claims under the South Carolina Human Affairs law and bring under state law. Plaintiffs' lawyers generally like to be in state court more. This would allow them to bring these types of cases in state court as opposed to federal court. So this is definitely a bill to keep an eye on. I'm not sure its prospects for this session, but it does have a fair amount of support. Wouldn't be surprised if it passes sometime in the next few sessions.
All right, back to me. Thank you, Perry. Very interesting. A lot going on in South Carolina. All right, so we're going to talk about the Build Back Better Act. This has been passed by the House on November 19, and the way that it's being pushed, or the way that it's being proposed, is pursuant to the reconciliation process. And so, as you know, and from past experience, that tends to be an easier way to get legislation through the Senate because it's a simple majority. Certainly, an act like this, a proposed bill like this, would not pass probably in the any other vein, and it may not here either. But there's a lot of it that applies to employers. I need to move one thing. Sorry. I've got the chat box up. Here, there's a bunch of questions in there for you, by the way, that I left.
Yeah, I'm looking through.
So the Congressional Budget Office believes that this bill will decrease national deficit by $127 billion through 2031, which I find interesting. You can see how it proposes to do that. A 15% minimum tax on U.S.-based corporations with over $1 billion in profits, surcharges on stock buybacks, and high-income taxpayers who earn $10 million or more. I feel like this is reminiscent of Affordable Care Act, where the estimates, and not to slam the CBO, but the estimates were far off, and it ended up being a lot more difficult to fund it. But it'll be interesting to see. What we want to talk to you today about is, what do you need to know about any provisions that might apply to employers? So next slide. The first one, I think, that's probably most important is going to be the paid leave bit. So this is 4 weeks of paid leave to any private sector workers. And it says for reasons generally provided under the current FMLA, but I'll tell you, the word generally is the operative here, because it definitely expands the application of that a good bit. For the reasons, as well as those who are eligible, as well as I think adding more reasons that historically weren't recognized under the FMLA. And you can see it increases the definition of what's considered family members to include siblings, grandparents, and other individuals whose relationship is equivalent to a family relationship. So that's sounding like language that they had in the FFCRA, and certainly a lot broader than the FMLA is now. This applies to any employer, regardless of size or length of service or job type or worker classification. So in regards to length of service, again, that's very different than FMLA, which requires, as you know, 12 months in the last 7 years, and then 1,250 hours in the last 12 months. And so this is a very expansive paid leave provision. And as an employer, you're nervous because you're like, great, are they going to make the employers pay for it? At least in the way that it appears now, the answer is no. It's going to be financed by a public program that's applicable to both private and public employers, and that'll be run by the Social Security Administration. Or if there is a state plan that's already enacted, which I believe from what I've seen, there are 9 plans in place of this nature that provide equal or better benefits than those proposed in the BBBA, then the state plan will continue and the federal plan won't take place there. Or if it's an employer who voluntarily chooses to offer this, the federal government will give partial reimbursement back to any legacy state plan or employer who is offering the coverage. So this is interesting because it sounds like mostly a public plan, a public paid leave plan. So we'll have to see what happens. Next slide. The Affordable Care Act, the 2022 affordability test for employer-sponsored health coverage is currently at 9.61%. That was set by the IRS as it is every year. This was actually a lowering of affordability from the last year and the year prior. And so already that's caused employers to have to look at the cost of their healthcare plan to make sure that it is still affordable, or where it's not, that they're dealing with that issue for their lowest paid workers. Well, the Act proposes to even lower it from 9.61, which it is now, to 8.5% of affordability from 2022 through 2025, and then set a rate at 9.5% of household income after 2025. Another thing that the Act purports to do is close the Medicaid gap by providing premium tax subsidies, which, as y'all know, that's through the exchange or the marketplace, through 2025 to people with incomes that are below 138 federal poverty level. For a family of four, that's $36,570. So that's interesting. The Medicaid gap is a real thing, and it has impacted, let me just be clear, harmed hospitals, harmed businesses. Some hospitals, smaller ones, community ones, have actually had to close their doors. And so this is not necessarily a bad thing from the healthcare standpoint, healthcare industry standpoint, and would increase, presumably, more folks that are insured. And that's good for all of us who pay healthcare premiums. So the Act does purport to try to deal with the gap. As everyone knows, the 2012 Supreme Court opinion in regards to the Affordable Care Act did specifically say that it was a state-by-state choice on whether or not a state chose to expand Medicaid, and certainly South Carolina was one that did not. And I haven't looked at the current figures, but I think there's about 35 that have, and don't hold me to that. I need to look at that, and then a number who haven't, of the remaining states. The Act purports to increase premium subsidies through 2025 for the group that falls into the 100% to 400% federal poverty level. And so for a family of four, that's $26,500 up to $106,000. Those who have unemployment would automatically qualify for premium health subsidies. And, just overall offers premium tax credits to lower individuals and employees who have access to employer plans to still receive marketplace credits without an employer penalty. So this will be interesting to see what happens to the Affordable Care Act, assuming this Act is passed. The labor penalties have increased. And in fact, July 14, I put July, it's January. This was my fault. January 14, 2022, a new rule increasing the penalties was issued by the Department of Labor for a number of categories that the Department of Labor Wage and Hour Division handles. And it became effective January 15, 2022. And I give you the link to the actual penalties, and it lists them by categories, and you go through them and figure out which ones apply. The biggest jumps are in the child labor laws and in wage and hour issues, but there are increases throughout all of the penalties. The Department of Labor indicated that these were done for the purpose of inflation. The last time that those had been done were in 2015. The National Labor Relations Board has increased penalties, civil penalties, substantially, up to $100,000 and $50,000 for some. And then OSHA has increased their penalties overall 6.2%. So significant amounts. And I'm glad to provide you any company that's interested, any attendee that's interested with the specific charts for these. But these penalties, this is under Build Back Better Act, but these penalties are already in place. And so these are important things to remember and to keep in mind when you're dealing with the issues that these penalties are implicating. Next slide. All right, so it is anticipated that the DOL overtime rule, as it's termed, and the NLRB's joint employer standard will be revised. Now, no surprise about the joint employer standard. Anytime you have a new administration in, the new administration, if it's a change in political party, will put folks in the NLRB board seats, and historically, whether it's Republican or Democrat, definitely guides which sort of joint employer rule we're going to be operating under. So it's maddening for employers. And the Department of Labor is wanting to revisit what it called the overtime rule, which I think was a true misnomer, because it didn't apply to overtime. It simply applied to what exempt salary basis salaries should be. And as you recollect, at the time that the bill was, at the time that the rule was originally passed, it would have increased the salaries from approximately, I think it was $420, $460 to $913 a week, or $47,476 annually. That ended up being lowered substantially while President Trump was in office. And now it's $35,568 annually, $684 per week. And so that is the minimum salary that anybody who is classified as an exempt employee can be paid. But the thinking is that the Department of Labor now, under a new administration, is going to come back and come up with a new rule, a new NPRM in April 2022, revisiting it. And that the thinking is it's even going to be higher than what was proposed during President Obama's administration. And also that it would be regularly updated. So that's something to keep your eye out for. Of course, any NPRM is going to be subject to a lot of comments from different interest groups. And so we'll see what happens. The NLRB rule, can you pop back? Just pop back. I wanted to talk about the joint employer rule just a little bit. It'll be a little bit harder this time for the NLRB to revisit the current standard, because the last NLRB in 2020 actually issued a rule, 29 CFR 10340. So in this instance, the NLRB will have to rescind that rule and just allow it to go back to what it was before, which was common law, or rescind the rule and replace it. So in the past, many times when a new administration has come in and a new board appointed, the new board just issues new guidance on what should happen. And, it's all based on case law, and the board can decide it's going to be this, it's going to be that, and the board has case-making authority. But the last NLRB board actually did pass a rule, and this is in place. And so it is not going to be as easy for the current NLRB board to do something about it. But the options are either it gets rescinded and there is no replacement. If that's true, then it's going to go back to the 2015 Browns-Fairing standard, which is very broad. If you all remember it, it is a situation where if you're an employer and you also have a supplier of temporary staffing employees, both of you would be considered employers, even if the owner, the employer is not actually exercising any control over the employees. The fact that it could do so, the fact that it has general guidelines about its business operations, and the fact that it owns the workplace and outlines what the goal of the workplace is, what types of jobs need to operate the business, that would be sufficient for someone to be considered a joint employer. So this will be interesting to see, and it is something that's important that we'll need to keep our eyes out for, because once it changes, if it changes, and it's anticipated to be a process that starts next month, then employers will have to again make sure that they're not unintentionally falling afoul of this. As a reminder, one of the things that you can do is have a pretty strong indemnification provision in your agreements with your suppliers, your temporary staffing agencies. That will help you deal with the uncertainty of which board, which case is out there, what the law is. It will help you control it more in a contractual relationship with your supplier as far as who's responsible for all of the employee obligations. All right, next slide. EEOC priorities, they didn't really have an agenda that they issued, but these are the things that they're continuing to look at: systemic racial discrimination, and targeted outreach to veterans facing discrimination, dealing with the impact of COVID-19 on women in the workplace, women of color, women with children, pay equity. You heard Perry talking about that. That continues to be a big issue and a big focus for the EEOC, and as well as gender, transgender, and sexual orientation discrimination in the workplace as a whole. So more of the same from the EEOC, and they are staying current in regards to the topics that Perry covered. All right, so I'm going to do the next slide, and then I know Perry's got some things he might want to answer live in regards to some of the questions, but we're going to return to our DEI series. I think many of you have joined us for the first half of our DEI series that started last year with Perry and Brandy from Wren talking about pay equity in August. And we continued that through the year. We wanted to make sure we did the legislative update, as is our process, our plan annually in January. We're going to jump back to DEI for the remainder of the year through June, and then we'll take a break in July and start back in August with a new plan and more information. So February 24, February is Black History Month, and so we're going to talk about DEI efforts in regards to racial equity. March 24, Women's History Month, and we're going to be talking in line with what the EEOC is focusing on, is women in leadership roles in the workplace, how the pandemic affected women. So two different sort of parts to this series. I want to tell you that we have a great speaker that is going to be joining me and Demetrius in February, and then me in March. It's April Simpson, who I don't know if many of you know her, but she is actually a national DEI speaker, a national SHRM speaker, and a national Urban League speaker. She is phenomenal, an HR consultant, and also, HR manager in a large PEO organization. And so this was a really exciting thing for us to have April join us for these two sessions. April 28th, we have someone from the Hispanic Alliance coming to speak with us in regards to national origin equities. Perry is going to offer a mid-year legislative update in May, and then in June, we'll be addressing Pride Month and Juneteenth. And so we really hope that you'll continue to join us. And as always, please offer us any suggestions you have for things that you'd like us to consider and present on, because we're always looking for things that we can present on. And we of course want to present on something that you want to hear about. So Perry, I'm going to kick it back to you because it looks like you're getting more and more questions. And I didn't know if there's anything you needed to answer before we popped off.
I think I got everything. Teresa just asked one here at the end, and I think it was part comment, part question. She did ask about how COVID at the end, how do COVID tests measure up, home COVID tests measure up as opposed to other tests. It seems like they're sort of becoming more acceptable as a test to use for someone coming back to work. You probably saw the Biden administration's big push to get COVID home tests out there to people. You can go online and order, I think, 4 free tests per household, maybe something like that. And the idea is to keep movement in the economy going and keep people getting back to work. And so I think they're generally speaking, if you've got, and you mentioned you're an international company and you got people traveling and stuff. I mean, generally speaking, I think if you've got an employee who you're just saying, hey, you've been out of the country on business travel, you're coming back into the office, not symptomatic or anything like that, and want to give them a test just because they've been traveling, I think an at-home test can be appropriate for something like that. I think they're sort of gaining broader acceptance for general use in the economy, even though that they are, I think, recognized as being a little bit less reliable. Otherwise, I think I've answered everything, but if anybody, of course, has any follow-up questions or comments for us, you see our contact info there. You know how to reach out to us, and thanks for the nice comments from people in the chat. So thanks again.
Everybody have a great day.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.